hearing in the matter of NY, a child.
Mr. Twomey, had I not better say at first that we are making an anonymity order here, and the order is that no one will publish or reveal the name or address of the child who's the subject of these proceedings, or publish or reveal any information likely to lead to the identification of the child or any member of her family in connection with these proceedings.
My Lord Wood, we'd be most grateful.
Thank you.
Thank you.
Yes.
Lords, my lady, may it please you, on behalf of the appellant, I appear together with my own friends, Messrs. Horton and Leng, and Dr. George. On behalf of the respondent, Mr. Setright, Queen's Counsel, together with Mr. Jarman and Mr. Gratian.
Yes. There
There are interveners who have provided documents for the court to consider in the course of this appeal. Reunite, authored by Mr. Gupta, Queen's Counsel, Miss Renton and Miss Perrins. The International Centre for Family Law, Policy and Practice, authored by Mr. Hames, Queen's Counsel, and Miss Baker, who are both here, and Mr. Edwards. And the International Academy of Family Lawyers, the author, Mr. Scott, Queen's Counsel, who is also present.
It might be helpful for the court to say at this stage, in the light of the fact that the interveners will not be making oral submissions, that we have read the 3 sets of written submissions and accompanying material, and have found the submissions extremely helpful in all respects.
That's very great.
Thank you, Mr. Twomey. Yes.
Lord, this case is not about the existence of a power to order summary return of abducted children outside the Hague framework. We agree with everything that was decided by the House of Lords in Re J in 2006. But this case is very different. The father's case did not fail, we say, on a technicality. It failed on a fundamental error of categorization. This relocation to England was at no point in time wrongful. So when the trial judge turned from the issues arising under Hague, by way of an aside, he had in mind the use of the inherent jurisdiction. But he did not make orders under the inherent jurisdiction. He did not need to, because he thought that this was a Hague application that he had granted, but he was, we know, incorrect. Had he known the true position, then in our submission, he should have asked himself 4 questions. Firstly, what, if any, jurisdiction do I now have? Our answer to that is that there were no applications before the court, but for the one that he should have dismissed. The second question, subject to satisfying myself of the options, such as they might have been, in other words, had applications followed on at that point, not that there were any before him, which jurisdiction should I use? In other words, hypothetically, were applications to be made under the inherent jurisdiction, together with, or in the alternative, under the Children Act, which jurisdiction should I use? And in the case of either, what are the welfare issues arising in respect of those applications? And then finally, should I deal with all or any of them summarily? My Lord, only having answered those questions could he proceed. Yet in respect of none of these steps did the trial judge hear oral submissions, nor had he received written submissions. And of course, the consequences for the child and her parents were profound had the questions been asked. And it's perhaps unsurprising that the learned judge heard or received no such submissions, because it's very clear that in his judgment he regarded the inherent jurisdiction as a mere adjunct. His judgment was based, wrongly as it transpires, on this being a case of wrongful retention. So in the absence of any submissions in relation to any of the above matters, or any consideration of what might have been the answer to those questions, the welfare foundations upon which the Court of Appeal seek to uphold the trial judge's judgment are of the weakest, in order to uphold, in effect, an alternative case for the substantive order that was made erroneously. And so we submit that really there are 5 points. They're summarised at the back of our case, but it was not permissible, we say, to... Shall I take my little...
Yes.
So it's...
Oh, yes, right at the end.
Right at the end, MS 716 in the core volume. I set out there the 5 arguments that we seek to rely upon in this appeal. Not permissible to use the inherent jurisdiction to order relocation of the child. Even if it had been so, it was not open to the court to do so without application. In relation to the welfare assessment, it was not appropriate for that to be conducted summarily. Secondly, in any event, that assessment was deeply flawed. And thirdly, in relation to all matters relating to the decision of the Court of Appeal, it upheld a process that we say was thoroughly unjust. That these proceedings were proceedings under the Child Abduction Act of 1985, which incorporates the Hague Convention. At no point was there any reference in the course of those proceedings to any other applications. And so perhaps here I can just turn to address matters that have been raised on behalf of the respondent in respect of the suggestion that there might have been, at least in the minds of the lawyers, should have been perhaps, some acknowledgement that there were actual, to be inferred, potential applications under the inherent jurisdiction. So the first point is this, that in the skeleton provided by the respondent in the Court of Appeal, it was asserted that there was an application. That was...
Well, we see from your footnote that a learned counsel then appearing before the father agreed before the Court of Appeal orally that it was wrong that there'd been any reference to the inherent jurisdiction. Is that still the agreed position?
Well, I think the respondent's position is nuanced in that it is, I think, suggested there might have been. Perhaps Mr. Setright in due course...
Well, let's hear what he says about that.
Yes.
At the moment, I think we're proceeding on the basis that, in effect, before the judge, there was no indication whatever that the inherent jurisdiction was in play, and that the first your side heard about it was when they either read or heard, I don't know whether the judgment was delivered orally, the final paragraph of MacDonald J's judgment.
That is the basis upon which we do ask you to proceed.
Very well.
Could I
just be clear?
Yes.
There's 2 ways in which we can look at whether the inherent jurisdiction was in play. One matters for other arguments. You're dealing with the question of whether you knew that there was going to be an application for summary return under the inherent jurisdiction, which is possibly a different question from whether anybody had invoked the inherent jurisdiction in these proceedings. It had been invoked, hadn't it? Because the orders that were sought to bolster the Hague process were inherent jurisdiction orders.
I don't think we would accept that necessarily, and the reasons are, perhaps I can take them in this way. Firstly, the correct form for an inherent jurisdiction application is Form C66. We can furnish the court, I think, in due course with that form. But the form that was used is the form that appears in the appendix at MS 833, which is Form C67. And then the remedies can be seen at 837. Thank you. Now, those remedies mirror, almost word for word, the wording of Section 5 of the 1985 Act.
What page are we on now?
My Lord, 837.
837.
It's box 4,
Yes.
and the second paragraph is the request for a return. But the first paragraph, and if it would assist the court to look at section 5, then that is, as it might, that is in our authorities bundle at tab 1. And section 5 appears at MS page 8. If one has, as it were, an eye on both pages, one can see that the first paragraph reflects the wording to the word of section 5. So we say these are statutory powers under section 5. If we're wrong about that, then what we say is, insofar as those interim remedies were sought, they were sought, if they were sought under the inherent jurisdiction, they were sought and granted, and that was that dealt with. So the inherent jurisdiction was, if it was ever in play, was no longer in play. And so what remained was the decision about the return of the child. And we say that this paragraph in part 4 of the form is entirely appropriate. This is an entirely appropriate way for the applicant, as he was, to have proceeded. There's reference to the Senior Courts Act appearing at the head of orders made by the court. Lady and my lords, that takes the matter no further, we say, not least because one only has to look at section 19 of that act. 19.2a is the statutory power under which a High Court judge exercises his jurisdiction or her jurisdiction. 19.2b is everything else, which would include the inherent jurisdiction. So a broad reference to the Senior Courts Act of 1981, or even as it appeared on the witness statement in initiating the proceedings, the Supreme Court Act, as it was, which is a mistake, of course. But in either event, it takes the matter no further, because this judge was exercising his statutory powers, and he has foundation for that under section 19.2a. So we say, to come back to the basic point, was the inherent jurisdiction in play at all? We say absolutely not, for those reasons. The child being present in the jurisdiction, and I believe there's no dispute between us as parties before the court, that the court, the trial judge, had the jurisdiction to make orders under the Children Act. And my Lord, Lord Wilson, indicated the use of the Children Act in the case of Re B. And perhaps just by way of an aside, it's helpful to look at Re B, which is tab 8 of our authorities bundle. And my Lord used that in respect of an incoming child, as would have been. And it's tab 8, which begins at MS 159. The particular quote is MS 199.
Yes.
Appearing at the top of the page, just below A. The Lord said this: were the court's eventual conclusion, this was a child, of course, who was in Pakistan, to be that it was in that child's interest to return to England, either occasionally or to spend time with the appellant here, or even permanently, in order to reside here again, whether mainly with the respondent or otherwise, its order could include consequential provisions under section 11.7d of the 1989 Act. For the respondents to return her or cause her to be returned to England for such purposes. And there is, it's well known that the court, in making what used to be a residence order, now a child arrangements order, can apply attached conditions under section 11. And my Lord had those conditions in mind. My Lord had in mind, we say correctly, if we may, the Children Act as the statute providing the remedy. Now, if the Children Act had been invoked, we say at that point, the next reference is in the same bundle of authorities. If my Lords and my Lady would be so good to turn to divider 11, which is the case of Re F. And apart from one reference, just, if I may refer to the head note alone, REF is a helpful case in respect of relocation. It's the Court of Appeal at MS 256, the head note discloses paragraph 1 underheld that the only principle of law was that the child's welfare afforded paramount consideration. Then, importantly, we submit it was well established where there was more than one proposal before the court, a welfare analysis of each proposal would be necessary. The sophistication of that analysis would depend on the facts of the case. Each realistic option for the welfare of the child should be validly considered on its own internal merits. That prevented one option from being sidelined. And not only consider both parents' proposals on their own merits, and by reference to what the child had to say, but it's also necessary to consider the options side by side in a comparative evaluation. So, Lords Milady, that is precisely the task that should be undertaken by a family court judge in this case, once the Hague matters were out of the way, if the dispute remained between the parties.
Well, that raises the question whether the appropriate procedure in an application such as REF, where the German mother said it would be better for the child to live with me in Germany rather than in England now, is really apt to the order that was made by the Court of Appeal. You say it is. But there is quite a gulf between the two inquiries, because one is a decision on where it would be better for the child to live in the long run, whereas this was a decision that it would be better for the Israeli courts to resolve the disputes.
Yes. So I think there may be two ways in which the word summary might be used in this appeal. Summary in the sense of the forum question, to which my Lord has just mentioned. Is it better for the courts of another country to decide this child's welfare? But that, of course, outside of the convention would be a welfare decision in itself. But that is a summary forum style. So we can use summary in the term of a forum welfare question, or summary in the terms in which, in this case, the current president gave an example. It's at 273 to 274 MS, right at the end of the report.
Yes.
And to the bottom of 273. So in some cases, 4 or 5 lines up, for example, where the issue is whether locations for a handover under child arrangements order to take place at McDonald's or Starbucks, the evaluation will be short and very straightforward. In other cases, for example, a case of international relocation, which we say this was, albeit very different, the factors that must be given due consideration and appropriate weight on either side of the scale to the welfare balance may be such as to require analysis of some sophistication and complexity. So, in due course, if I may come to, in a little more detail, the issue, but the question, I suppose, is what is the question? So under Section 1, the welfare, the very first line of the Children Act, asks the court to consider the issue. So what is the question?
Mr. Twomey, it's only a label. So long as we all know what we're talking about, the label doesn't really matter. But for what it's worth, it might be helpful for you to know that the preliminary view of the court is that this is not properly to be categorized as a relocation case.
Lord, in relation to labels, it's certainly not a return case, we would say. It might be something in between, but it's closer to relocation than return.
Insofar as the word return suggests that the child is here wrongfully, I understand your point. On a wider basis, it could be called a return, but we are sensitive to the point that you must be making and that I have articulated.
What we say is that, in any event, a summary determination was not appropriate in this case. And as I say, the Children Act the first line of the Children Act, is when a court determines any question with respect to the upbringing of a child. This is MS 15 divided
Well,
2.
we should know that.
Well, yes, but it's well known, of course, but it's perhaps interesting to ponder that first line. What is the question? Is the correct question in this case, or was the correct question to have been in this case, should the courts in Israel determine the welfare for this child, or was there a broader welfare question which would have been engaged once the parties were told Hague is out of the way, now what? What would the father's ultimate case have been? Would it have been that the child be cared for by the mother in Israel, so what the Australians refer to as a coercive relocation, requiring the primary carer to move, coercive not in the domestically abusive sense, but in requiring someone to move against their wishes with a child? Would his case have been that he wished to care for the child? And what would the mother's case have been? Well, the mother's case would have been clear. It would have been an application for a child arrangements order for the child to reside with her in this country. And this court had jurisdiction to do that. And of course, at the time the judgment was given, and at the time that the court looked to welfare, which could only be at the time of judgment, although many of the considerations go back to the 10th of January as the date when the parties separated. But the date the judge gave his judgment, it may well have been the case that this child was, by then, habitually resident in this jurisdiction. And so that this court, had there been a determination about that, which there was not, this court would have had jurisdiction primarily because of habitual residence. And of course, that would be relevant to any forum discretion. As we see, that is the discretionary exercise undertaken by this judge. But it's also relevant to a wider ranging, broader welfare inquiry.
Of course, as we know, the inherent jurisdiction order was not made by the judge, made by the Court of Appeal.
Right.
It was made in June. So I suppose a subsidiary question is whether one should be looking at these matters, including habitual residence, as of June. And then the question for Mr. Setright would be, what was was there any such focus?
There was no such focus in the Court of Appeal. This, in fact, having made the determination in the Court of Appeal that it was not a wrongful retention, the judge was wrong about that, we had to consider carefully the powers of the Court of Appeal, of course, are to make the orders that could be made by the judge below. So I suppose it might be said that the judge below might have made, had there been an application and had there been argument and evidence, we would say, but certainly argument in relation to it, then I suppose the Court of Appeal might say, well, he might have made the order then, and so one looks to April rather than June. But the safer course in relation to their determination of our appeal and our submission would have been to carry out the exercise in June.
May I ask, were these points made to the Court of Appeal during the course of the hearing? Did you invite the Court of Appeal, if you were right on your first proposition, to consider the issue of welfare in more detail than the Court of Appeal ultimately did?
No, my lord, no.
You didn't?
No. We were looking at the judge's exercise of his evaluation, the judicial evaluation that was in issue. And of course, this issue arose in the course of argument. It wasn't an issue that was identified for the Court of Appeal hearing, but the Court of Appeal was considering and ultimately did uphold the judgment or the order made by the judge on the basis of that discretion that he exercised. And so there is some lack of clarity, for example, as to what the judge meant when he talked about habitual residence. Had habitual residence been present at the time, he probably meant the 10th of January. But in relation to the discretionary exercise, we didn't ask the Court of Appeal to do that. Though it would have been open to the Court of Appeal to do that, arguably. But in our submission, the point is that there should have been no welfare determination other than one based on proper welfare evidence, proper and full welfare inquiry, because this is not the sort of case that justifies a summary determination.
So you invited the Court of Appeal, or submitted it would be appropriate for the Court of Appeal to remit it? Was that submission made to the Court of Appeal?
Well, may I just check? I don't think I did. Lord, no, we didn't. I just wanted to be clear that I didn't do that. I didn't. And firstly, because we were asking the Court of Appeal to set aside the judge's order. And secondly, we say there was no power to make an order under the inherent jurisdiction without an application in any event. And that's the second part of ground one, that there is in fact no power to do so.
But it must have been clear in the hearing, because the question was posed at one point, wasn't it? Is there anything else you would have said if you'd known that this application was on foot?
Yes.
It must have been clear that one of the possibilities that was going to emerge from the hearing was that the court was going to say there was jurisdiction to deal with it this way, there was sufficient application made, and at that point the question arises whether the Court of Appeal is making the decision itself at that time, or alternatively exercising the powers that the judge would have had at the time before, or alternatively the whole matter should just be remitted. So was there any discussion of that?
I think it was entirely clear that it was the second of those three courses that the Court of Appeal was likely to be embarking on.
Which was making its own decision?
No, that it would be upholding the determination of the judge below. And therefore there was a discussion as to whether the judge below had sufficient welfare information.
But he hadn't decided it.
Quite.
So actually, the first decision was the Court of Appeals.
Mm.
Well, may I think about that?
Yes, it's not an easy question. And it gives rise to the question of when the Court of Appeal exercises the powers of the judge below,
Yes.
is the order made as at the time the judge heard it, or is the order made when the Court of Appeal makes it? Don't answer straight away.
My lady, I attempted an answer earlier in answer to my Lord Wilson, but perhaps I can think about that with my helpful assistance and come back to the court in reply, perhaps.
Yes, please, proceed.
I'm grateful. So we say, in summary, that it was wrong to use the inherent jurisdiction. It should have been the Children Act. The decision was made without consideration of whether the court was permitted to invoke the inherent jurisdiction. Without consideration whether, if so, an order could be made without an application to that effect, whether a summary process was justified in the absence of an anterior wrongful act, which we say it was not, whether a decision should have been made without adherence to the statutory scheme, the safeguarding that arises under the statutory scheme, the fuller welfare inquiry, the analysis of the competing welfare proposals. And this was all without submissions on any of those, or any mention of the inherent jurisdiction that the Court of Appeal upheld the judge's decision below. Lords, in relation to ground one then, the primary point we make is that there is a central principle that one should not cut across the statutory scheme. And we say that our submissions in that regard are supported by practice direction, case law, and the primary statute, including the way in which the Children Act came into being. What we suggest is that the first paragraph of the practice direction provides what this court should, in our respectful submission, aim to give, which is clarity and simplicity to this issue. It's at MS 33, the third divider of the authorities bundle, which is a helpful recitation of what we say is the common law position. So the second sentence is clear. The court may make any order or determine any issue in respect of a child when exercising its inherent jurisdiction, unless limited by case law or statute. Such proceedings should not be commenced unless it is clear that the issues concerning the child cannot be resolved under the Children Act. So, my Lord, had the trial judge had thought of this, he should not even have gone on to look at the inherent jurisdiction without first asking himself whether or not the issue could be resolved under the Children Act.
As I understand it, the issue is joined in relation to the final sentence of paragraph 1.1. The principle in the second sentence isn't disputed. So it's the third sentence is the one that you're founding on, that if there is a statutory procedure for resolving it, it has to be used.
Well, yes. Well, that's what we rely on as being good law, and we base that upon a number of authorities. But it is, of course, it's the most fundamental question for a court. What is my jurisdiction? In relation to matters concerning the welfare of the child, should the statutory code be used to meet the facts in issue? And if not, and only if not, should one look beyond the statutory code to the inherent jurisdiction? And this was the tenor of Lord Justice Waite's comments in the Central Independent Television case, which appears at tab 16. And in particular, MS 363 to 364. MS 363 at H. The prerogative jurisdiction has shown a striking versatility throughout its long history in adapting its powers to the protective needs of children in all kinds of different situations. Although the jurisdiction is theoretically boundless, the courts have nonetheless found it necessary to set self-imposed limits upon its exercise for the sake of clarity and consistency, and of avoiding conflict between child welfare and other public advantages. The medical intervention case provides a recent example. And in CT, which is at, I hope, tab 10, again, Lord Justice Waite, MS 245, under the heading Status of Wardship. Scheme of the Children Act is to establish a statutory code for both private and public law. It implements the proposals in the Law Commission paper of numbered 172.
I'm sorry, which page are we on?
Lord, 245, internal page 282.
Just under the heading, the status of wardship.
Thank you.
It says, the Act to establish a statutory code, private and public law. Next paragraph, the jurisdiction is not only circumscribed procedurally, the court's undoubted discretion to allow wardship proceedings to go forward in a suitable case is subject to their clear duty, in loyalty to the scheme and purpose of the Children Act legislation, to permit recourse to wardship only when it becomes apparent to the judge in any particular case that the question which the court is determining in regard to the minor's upbringing or property cannot be resolved under the statutory procedures in Part 2 of the Act in a way which secures the best interests of the child, or where the minor's person is in a state of jeopardy from which he can only be protected by giving him the status of ward.
In the Texan case, didn't we follow up a failed Hague application with an order under the inherent jurisdiction?
Yes, that's right.
If so, were we wrong?
Firstly, the matter wasn't argued before this court. The order that the court made was the right order. It was, without doubt, an order that...
This is Riel 13, isn't it?
13, Lord, yes.
Perhaps we needn't turn it up unless you want to. Yes?
So, my Lord, quite right, of course, in that case there was, before the court, an application at the same time under the inherent jurisdiction.
I know, but your case is it ought to have been under the Children Act.
Yes, it is. I mean, that's what we say plainly to this court, that,
Yes.
on reflection, wasn't argued by the parties before the court.
No.
And and indeed the result would not have been different.
No.
This depends on this court having jurisdiction, the court in this country having jurisdiction to hear a Section 8 application, doesn't it? I'm not talking about inherent jurisdiction now, I'm talking about geographical jurisdiction. And there's the point raised by Reunite, which is that on their argument, paragraph 36 of the intervention, there wouldn't be jurisdiction because it would fail to get through the Family Law Act jurisdiction provisions.
So we don't agree with that at all.
If that was right, then your argument would completely fall away, wouldn't it? Because there would be no alternative but the inherent jurisdiction.
I think that's right.
Yeah. So it depends on that argument being wrong. And no doubt you'll deal with that at some point.
Well, yes. Well, I can deal with it now, which is to say to this court that one looks to the Family Law Act of 1986 for the jurisdiction.
So where do we have that?
Sorry, it's the respondents' authorities. It's divider 2.
Yes.
So just before I delve into the Family Law Act of 1986, the factual situation, of course, very different, where in that case one had to rely upon nationality.
Which case? I'm looking at this in a vacuum.
Yes.
And I'm working on the basis that the judge hadn't found habitual residence here.
That's right, but he should have done. He should have made a determination at the time he made his decision.
Yes, but supposing he didn't find habitual residence, because that's where he was at the end of his judgment.
Yes. Well, then we say that on the basis of the child's presence, there is jurisdiction. So Section 1.1a, Section 8 order, which a child arrangements order would be, is there defined.
Yes.
And then Section 2.1, the court in England and Wales shall not make Section 1.1a order with respect to a child unless, and then A or B. So in relation to A, jurisdiction under the council regulation, we say would arise because this child was not habitually resident in any member state. And as a consequence, Article 14 is employed, relying on domestic jurisdiction, which is presence.
Understand.
Alternatively, if we're wrong about that, the condition in Section 3 is satisfied, Section 3 arising by way of 2.1b2, and Section 3 refers to the conditions as in the alternative habitual residence or presence. So in our submission, there was most certainly a power to be exercised, a jurisdiction under the Children Act.
It depends on what it means by neither the council regulation, etc., applies. It was held in re-I and so on to apply. You don't get to Section 3 unless you can establish that it doesn't apply.
Yes, well, that's why I start with the first provision. It's somewhat circular. And in any event, we would say that if we're wrong about all of that, excuse me, then there's Article 20, where the court can provide, under Brussels II, urgent protective measures, which could include where the child should live. But our primary assertion is that there was the jurisdiction to make orders under the 1989 Act, and that should have been what the court did. As I was addressing the court in respect of the statutory scheme not being cut across, that is a long-standing common law approach, starting with De Keyser, the Attorney General in De Keyser. That's in tab 7, and that, of course, is the Crown's prerogative, and wardship or the inherent jurisdiction is a derivation of the Crown's prerogative. Tab 7 of the authorities, and I ask the court just to consider some of the speeches in that, starting with Lord Dunedin, internal 526 MS 103. It's the second half of that page, beginning nonetheless, about 8 lines up from the end of the middle paragraph. It is equally certain that if the whole ground of something which could be done by the prerogative is covered by the statute, it's the statute that rules. And on that point, he upheld the dicta of the Master of the Rolls in the Court of Appeal in respect of that case. What use would there be in imposing limitations if the Crown could, at its pleasure, disregard them and fall back on the prerogative? And the reasoning a little lower, inasmuch as the Crown's a party to every act of Parliament, it is logical enough to consider that when the Act deals with something which before the Act could be affected by the prerogative and specially empowers the Crown to do the same thing but subject to conditions, the Crown assents to that, and by the Act of the prerogative being curtailed. And
I mean, that seems to be rather different from what was said by Lord Justice Waite in the Central Independent Television and CT cases. Because as I understood his statements there, he accepts that there is still an ongoing inherent jurisdiction, but there's also a statutory jurisdiction. Yes. And he says as a matter of priority between which one you choose, you start with the statutory one. But that doesn't mean that the inherent jurisdiction has disappeared. Whereas De Keyser is about actual loss of prerogative powers, because in De Keyser, what they were looking at was to see whether there was any prerogative power left at all. Answer, no, because statute had occupied the field.
Yes, but if, for example, if that statute were to go, like the carpet on the rug on the floor, if the rug is lifted, the floor is revealed. So if the statute goes, the inherent jurisdiction returns. And the wording used by... so I think, to answer my Lord's first point, that Lord Justice Waite is aligning himself more with the first passage to which I referred, which is...
Statute that rules.
Yes, exactly. And their lordships describe this in different ways. So Lord Atkinson says the statute abridges the royal prerogative. Lord Sumner says it abates the royal prerogative. And there's good reason for it. And Lord Parmore at 568, which should be MS 155, I think. 145, sorry. Provides the reason. The growth of constitutional liberties largely consists in the reduction of the discretionary power of the executive, the extension of parliamentary protection in favour of the subject under a series of statutory enactments. The result is that whereas at one time the royal prerogative gave legal sanction to a large majority of the executive functions of the government, it's now restricted within comparatively narrow limits. And we would say that's particularly important in this case, where the statute has developed in a way that the common law would not or has not in respect of matters relating to domestic abuse. And in that respect, the practice direction 12J is of particular significance in this case. I'll come on to that in due course, but we have a statutory code which, if the respondents are right, then they challenge, do they not, significantly long-standing common law authority. So they say in their document that, so that's at 1233. So I think there should be a supplementary core bundle which contains the respondent's document, I hope. In the case of the respondent is the second divider.
Now, what is this bundle? Do you mean respondents' authorities? No, you don't.
No, it's a slimmer bundle. It's
That, yes. Well, all the cases apart from yours. Well, that's what I've got in here, right?
All the written cases,
yes,
yes.
yes.
Yes,
Thank
we've
you.
got that, yes.
So it should be 1233.
Yes.
And it's paragraph 54A, and this is repeated elsewhere, or similar words are spoken in the document. The implementation of a statutory scheme for the making of relocation orders does not prevent the courts from making similar types of orders in the exercise of the inherent jurisdiction. Well, we say fundamentally no. We disagree. We rely on long-standing, we say, House of Lords authority, illuminated by the Court of Appeal in the judgments of Lord Justice Waite, to which I've taken the court. And it is the respondents who invite the court to depart from common law. Because in relation to...
You're right to look at the clock. You've got limited time.
Yes.
Most curiously, it's been agreed that Mr. Setright will have more time than you. That's most unusual. Usually the appellant has longer than the respondent. But you've got very limited time. You've got a lot of ground to cover. Ground 2 is very important.
There's not actually more time, but because the appellants have given themselves an hour in reply.
Oh, in reply, I see.
The difficulty in this case, at the time those times were agreed, we didn't have the respondent's case.
Anyway,
So,
I won't go on about it, but you've got a lot of ground to cover.
You're fully entitled to eat into your reply time by continuing your principal time.
That's a good idea.
if I may do that,
That's a good
that would
idea.
assist the court. It would certainly assist me if Mr. Setright is content.
I'm most content, my lords and my lady, so long as it doesn't diminish our block.
No,
It
it won't.
just transfers it later in the day.
No, that which is taken now is lost later.
Yes?
Thank you. Lord, can I deal with the summary return under the inherent jurisdiction, the development of that, by starting with the case of Riel, which is in the Respondents' Authorities bundle, which is the well-known judgment of Lord Justice Buckley, often quoted. It's tab 9 of that Authorities bundle. And one can see in the head note, this was an English mother married to a German national, children domiciled and resident in Germany, and she obtained consent to come here for a holiday, but retained the children. She always had the settled intention of leaving her husband and living permanently in this jurisdiction. The head note tells us that the court heard the case on a full investigation of the facts, evidence from both parties, and the conclusion was that it was highly desirable that the children should continue to be cared for by their mother, but as they were German children, their long-term welfare pointed overwhelmingly to a return to Germany. So that is a welfare outcome that is perhaps not surprising, but the court considered everything in the round. And well, I say that because it's important to bear that in mind when one comes on to consider the words of Lord Justice Buckley, which are often relied on. This was not a summary return case. And this was it was a full inquiry into their long-term welfare. And it was that full inquiry that led the judge to order the return of the children to Germany. The ratio of the trial judge can be seen at 265 in the law report. It's between, just below C, it starts, and in particular at D, the the correct approach is this. They're German children. They were 8 and 10. They have always been brought up in Germany. They're German nationals. They ought to be able to look forward to a future in their own country. Are the proposals of the father or the mother likely to promote their welfare, having regard to these long-term objects? It's perfectly plain that those considerations point overwhelmingly to their immediate return to their own country, to a resumption of their education in their appropriate schools, which was unfortunately interrupted by the mother's decision. So, wrongful act, children of some age, 8 and 10, brought up until that point of the wrongful act in Germany, overwhelmingly the welfare required them to be returned to Germany.
Did you say that this was a case of a full inquiry into welfare?
Yes, it was, my lord.
I mean, look, between G and H, a full investigation of the merits may be incompatible.
That is a full investigation in Germany.
In an English court. Full investigation of the merits of the case in an English court may be incompatible with achieving this. I thought this was the foundation of the summary return jurisdiction.
The foundation comes from Lord Justice Buckley on the previous page. And so we start really in his judgment at 264. In the second paragraph, how then do the kidnapping cases fit these principles? And he divides it into two, where the court has embarked upon a full-scale investigation of the facts. In other words, even a wrongful act can necessitate a full-scale investigation. The applicable principles, in my view, do not differ from those which apply in any other wardship case. The action of one party in kidnapping is doubtless one of the circumstances to be taken into account. The court may conclude that notwithstanding the conduct of the kidnapper, the child should remain in his or her case. That is based on the case of McKee and McKee, which is a case in the Ontario court where there was a full merits inquiry lasting some 11 days, in fact. Or it may conclude that the child should be returned to his or her native country or the jurisdiction from which he or she has been removed. Then this, where a court makes a summary order for the return of the child to a foreign country without investigating the merits, the same principles, in my judgment, apply, but the decision must be justified on somewhat different grounds. And there then follows the justification, which has underwritten the development of the common law and the use of the inherent jurisdiction to meet these occasions where a child is summarily removed from the country of his native land to another country where he may not speak the language, divorced from the social customs, the contacts he's accustomed to, his education, all matters which are described in Lord Justice Buckley's quote as psychologically disturbing. So abduction is well established as harmful. And so this is in our submission, this is where the concerns about abduction come from. But one has to firstly remember, I submit, that the court has a choice to make whether or not to conduct a full welfare inquiry or a summary welfare inquiry, but only the summary comes from the wrongfulness. That's where this comes from. And
but there was no suggestion in this case that there was on foot, or there were on foot proceedings in Germany at the time.
No. And of course, that might be, in a given case, a relevant consideration.
Well, that is a particular feature of this case, isn't it? That the Court of Appeal were looking to see that welfare inquiry conducted in the country of the child's habitual residence.
Yes, in a strictly forum summary approach, that would be relevant. But it would, we say, it should have been considered, if it was considered, it should have been considered within a detailed welfare investigation of the merits of the competing cases, which of course had not been crystallised because the court was only looking at whether or not the child should be summarily returned. The case for the mother in this country, what life would look like for the child in her care in this country, had not been crystallised. The father's case in Israel had not been crystallised in his care or in the mother's care. So that would be a factor, of course. But interestingly, in this case, it may well have been that by the time the Israeli jurisdiction was invoked, the child was already habitually resident in this jurisdiction.
But may I just ask about the habitual residence? Because as I understand it, permission to appeal to the Court of Appeal on habitual residence was not given. And it wasn't suggested to the Court of Appeal that the habitual residence might have changed between the hearing before the judge and the Court of Appeal, which would demand a new inquiry into habitual residence as of the later date.
That was most certainly part of our argument, that there was a decision to be made in April by the trial judge based on the welfare as of April, because it was a welfare determination apparently under the inherent jurisdiction. It's a welfare determination. And so it had to have been based at the date at which that determination was made. You wouldn't have any welfare determination based on some historic set of facts. You would make the decision there and then. And what we know about habitual residence is that the decision relates, it would appear, the decision on habitual residence relates to the 10th of January. And now, the 10th of January really has no moment, it has no relevance. It had every relevance at the time the judge was looking at the 10th of January, because that was the point at which the parties separated. That was the point of alleged wrongful retention. Stepping away from that, the 10th of January is just a date in the history. The real important date is the date at which the judge makes a welfare determination that's in the best interest of this child to be returned to Israel. And that was April. And that is a point we made to the Court of Appeal. And so, in summary, what we say is there must be a welfare determinant, something that overwhelmingly requires the child to be summarily returned. Wrongful abduction, wrongful removal, retention, breach of custody rights, just such a welfare determinant. And so it was in the Texan case.
Mr. Twomey, for the record, I think I've got to apologise. My recollection of this old case was wrong. It is always regarded as the case which starts summary removal under the inherent jurisdiction with a limited welfare focus. But actually, since I've read on, when we needn't do so now, time is limited, to 265H, I see that actually this was a case where it was said that there had been a full welfare inquiry.
Yes.
My recollection has played me up, and I apologise.
No, my lord, not at all. And of course, the position is that this is relied upon as the authority, but in fact, it helpfully, I suggest, makes the distinction.
Yes.
So, my lord, in this case, was there a welfare determinant that required a summary determination? We say not. The appellant and respondent both gave up their jobs. Child left her nursery, they packed up their possessions, booked a one-way flight to London, signed a 12-month lease. Child was signed up to an attended nursery, was continuing to attend in April. Registration with local GP. Father was employed locally. The mother applied for credit, universal credit, and interestingly, on the basis of her habitual residence in this country. The date of that letter is the 11th of March, so predating. I'm not saying, of course, that an administrative decision of the benefits agency outdoes the trial judge's inquiry, but it is significant. It's, of course, significant that by the time the case came before the judge, had it been a Brussels II case, then often 3 months is a marker. It's not a given, but Article 9 refers to 3 months. If habitual residence has passed, then jurisdiction passes. And we say that the common law really reflects Brussels II revised. And very briefly, if we may look at the Respondents' Authorities Bundle, where they've helpfully set out Brussels II revised at the first divider. They don't refer to this as of direct application, of course, because it's Article 9, the child moving from one member state to another. But it is in distinction to Article 10. So Brussels II revised, in relation to children from member states, makes the distinction between children moving lawfully and children moving by consequence of wrongful removal or remaining by wrongful retention. That is the only point to draw to the court's attention in relation to that.
Whilst we've got it open, which is the preamble paragraph 6, explains how the grounds of jurisdiction are drawn up. 12, am I?
12, I believe. Framed in the best interest of the child
Yes.
and proximity.
And they are fundamentally based on habitual residence. And so a Brussels II evaluation of this case, as at, let's say, the 10th of January, if that's the time of the finding of habitual residence, would have said Israel's the right place.
Of course, the 10th of January is neither here nor
Well,
there.
yeah.
But yes,
Yeah.
yes. And so there was, in this case, there was an applicable statutory scheme. Section 8 of the Children Act would have done the job. There might have been a specific issue order sought, but no relief was sought. And we argue that, in fact, the use of the inherent jurisdiction was far from benign. It was far from benign because it cuts across the statutory scheme in a number of particulars, and we would identify the following. Firstly, there is, and again, to go back to the well-known Section 1 in the authorities bundle, one can see in tab 2 the statutory presumption at 1.2a. Now, that applies when the court is considered, 4a is when the court is considering a child arrangement, Section 8 order, doing this specific issue order. Subsection 7 is parental responsibility. There is a presumption, where we're talking about parents, that unless the contrary is shown, the involvement of that parent in the life of the child concerned will further the child's welfare. Of course, that statutory presumption is of particular note in cases where there are serious allegations of misconduct amounting to domestic abuse. And in due course, I'll ask the court to look at the relevant practice direction, but it would not be right for a court of full welfare to simply, for example, take allegations at their highest, because they would not be fair to either parent. They would not be fair to the person on the receiving end of the allegations, because there would have to be a presumption, if you take them at their highest, that they are right and that that person is not necessarily advantageous to the welfare of the child.
May I just ask, is all of this on the assumption that had the application been made under the Children Act, as you say it should have been, that would have demanded a full inquiry into the child's welfare, despite the fact that there were proceedings on foot in Israel at which the same inquiry, or the Israeli equivalent of the inquiry, would be conducted? What I'm struggling to understand is to what extent, in circumstances such as those of this case, is the court required to go into a full inquiry?
Well, I suppose in relation to the Israeli proceedings, the court might have been met with a forum convenience application. But insofar as it was not, then this court, exercising its jurisdiction under the Children Act, would proceed to deal with it in the usual way, which is dependent upon the relevant circumstances. So we are said by invoking the Children Act rather than inherent jurisdiction to be bringing upon this child delay, because the Children Act has certain formalities. We would say that's simply not right. It's not right procedurally, because the relevant practice direction permits for urgent hearings. There's a box one can tick even on the application form for hearing within 48 hours. So that's simply not right. Section 1.2, the avoidance of delay, applies to both the inherent jurisdiction and the Children Act. So the Children Act, we say, is a far better tool for a court so in relation to whether Israel was the right forum, that is a different question. And that is a question that arises on a forum convenience argument. But in the absence of a forum convenience argument, and it can only play part of the broader welfare inquiry, it is always for the trial judge to determine the extent to which that is necessary to have the broader welfare inquiry. But then we say this is a world apart from the Starbucks-McDonald's situation.
So how would this have played out in the Court of Appeal? Because as I understand it, there was it was anticipated that the Court of Appeal, were they to accede to your submission that the judge had fallen into error, what was the Court of Appeal to do?
Well, firstly, the first part is not entirely the case. We did not know what the court was going to do
Of course not.
in relation to that. It wasn't clear.
Yes.
So this passage relating to this argument relating to the inherent jurisdiction was very much in the alternative. And in relation to the alternative, I did, as it was raised in the course of argument and was not intimated on the papers, I did raise Practice Direction 12J as being the broader type of inquiry that we would have required of a trial judge determining the issues at the end of the Hague case.
I see. Okay, thank you.
So the statutory presumption is important. Section 1.3 is important. It might be implied into the inherent jurisdiction, but Section 1.3 only applies to determinations under the Children Act. And it's more than a useful checklist. The court has to have regard to it. So it must look at these factors. And in relation to domestic abuse, those matters come into many of the aspects of Section 1.3, particularly B, E, F, and G, and most particularly E, risk of harm. And so the next body of material, if I may, would be the practice direction itself, 12J, which appears at divider 4, MS 36. And of course, by way of background, it's right to say that this is not the first version of the practice direction. It is I think, second or third version of it. This version came about as a consequence of a working party headed up by Mr. Justice Cobb, which came about as a consequence of a 2016 publication by Women's Aid, based on its Child First campaign, asking for a change in the family courts following a review of 19 child homicides. There was then a parliamentary hearing by the all-party parliamentary group on domestic violence. That gave rise to a parliamentary briefing paper, and both papers include a number of recommendations for the Ministry of Justice and the senior judiciary. There was then a debate in Parliament in September 2016 when the Women's Aid report was considered. And in the light of those reports then produced and the debate, the president of the Family Division commissioned a review, and this is the document that comes from that review. And this is the document, this is the tool that it is, we say, necessary to look at where there are issues of domestic abuse, and certainly was not looked at here. So and we say this does apply, and I have read elsewhere that there is a suggestion that it might not from paragraph 1. Paragraph 1 says it's in an application for a child arrangements order, or in which any question arises about where a child should live. We rather think that means whether he or she should live in Israel, comes full square within that definition. And had the court, of course, it doesn't apply to the inherent jurisdiction, it only applies to the Children Act, and would have applied had there been a Children Act application by way of a Section 8 specific issue order, or had the mother applied for a child arrangements order. Look at my lord, my lady, Wood, the purpose. The purpose is broad. What the court's required to do in any case in which it is alleged, as it was here, or there is reason to believe that the child or a party has experienced domestic abuse perpetrated by another party, or where there's a risk of such abuse. Then there is, over the page, the general principle, which is significant. Domestic abuse is harmful to children, puts children at risk of harm, whether they are subjected to it or witness it, or live in a home in which it is perpetrated. Children may suffer direct physical, psychological, and/or emotional harm from living with domestic abuse, and may suffer harm indirectly, where it impairs the parenting capacity of either or both of their parents. then one can see the requirements which usually follow under paragraph 11 at the first hearing. That would not arise directly as a consequence of a specific issue order, but it would if there was a child arrangements order. Can I ask the court to briefly consider the directions on 16 and 17, MS 39? The court's required to determine whether it's necessary to conduct a fact-finding hearing. And the necessity comes out of paragraphs 36 and 37, which appear at MS 43. And can I just, if my lords, my lady, have MS 43, looking at paragraph 37, highlight in particular C, whether the parent is motivated by a desire to promote the best interests of the child or is using the process to continue a form of domestic abuse against the other parent. That ties in, we say, with the requirement in an ordinary relocation case to consider the motivation of the party seeking to remove the child to a new jurisdiction. Back, if I may, to 17. In determining whether it's necessary, the court should consider those matters set out, the nature and extent of the allegations which would be relevant to the issue before the court at G is especially significant. Before that, whether the factors set out in paragraphs 36 and 37 can be determined without a fact-finding hearing. And as I say, 36 and 37 direct the court to consider how they should proceed if there are findings made. And of course, in this case, which was a Hague case, none of this would arise, nor should it. In a classic Hague case where a 13B defence is raised, firstly, there will be no cross-examination of either party in relation to those allegations. It is a summary process, nor was there in this case. In a Hague case, there will simply be an assertion or an assessment based upon those allegations taken at their highest. Do the protective measures in the foreign jurisdiction or the return jurisdiction meet those at their highest? The Children Act, therefore, is quite different. It requires findings. It requires findings for a good reason, because if those findings are made, then they cast significant doubt on the capacity of the other parent. They may discharge the statutory presumption, and they go to the heart of the child's welfare, in particular, risk of harm. If those are not made, then the conclusion might be that the allegations have been fabricated, in which case they go into the same balances, but the other way. So a welfare determination is necessary in a Children Act assessment, but not in a Hague case. In any event, and this is now the final point in relation to ground one, the scheme for making orders under the Act. And can I ask the court to look again at the Children Act and now section 10, which has been divided to, and MS 23, please. Section 10.1 and 2.
Yes.
My lords, my lady, this is the power of the court in any family proceedings in which a question arises in respect of the child's welfare to make a Section 8 order. Family proceedings are defined and do not include the proceedings under Hague. They are defined at subsection 4. And so these were not proceedings in which there was the power of the court to exercise 10.1 of its own volition, consideration of Section 8.
Where did you say family proceedings was defined?
I think I've given my lord the wrong reference.
I think you have.
Find the right one. I'm sorry. Sorry.
8.3, I think. 8.3,
Thank you very much.
Thank you very
I
much.
think, maybe.
Yes. My lady, I'm most grateful.
Yes.
Thank you. The short point is that the 85 Act does not appear, so there was no power under the statutory code to simply turn to the child's welfare more broadly. And so we say if there is a statutory code which clearly prescribes when and when not a court may summarily turn to consider the child's welfare, then to utilise the inherent jurisdiction is to cut most firmly across that statutory code. And most certainly when there's no intimation of it. That, of course, is ground 3. We rely upon the absence of procedural rules as suggesting that there is a power of the court to make any order under the inherent jurisdiction without application. We rely upon the express wording of the Senior Courts Act, which expressly permits the court upon an application or without an application to deward a child. So the child can come out of inherent jurisdiction without an application.
Dewarding is different from other uses of the inherent jurisdiction.
Yes, it is a convenient machinery for the use of the inherent jurisdiction. It is a part of it, but that is the only way in which we found a power of the court to do something without an application, which broadly relates to the inherent jurisdiction. And we've set out the working paper of the Law Commission at tab 21 of our authorities bundle. And we say that, particularly at MS 480,
Yes.
sorry, that's where it starts, my lord, at 498, I think is the reference. Paragraph 2.6. The court itself cannot strictly apply for wardship, even through the official solicitor. So given the ability of a court to allow an oral application under the inherent jurisdiction, that might have happened. To deem an application to have been made following oral representations, or to accept an undertaking in the usual way to issue the application which is there in draft, there's no good reason, we say, to cut across the statutory scheme, which is what the Court of Appeal did in this case. We say it's not necessary to determine whether, more generally, it is possible to determine an issue under the inherent jurisdiction without an application. What we say is that where the remedy is one sought, or which should be sought, and is available under the statutory scheme, and where that scheme does not permit the court of its own motion to proceed to the statutory scheme, then in those circumstances there certainly should not be a power to utilise the inherent jurisdiction, for that would cut across the statutory scheme. Lord, I turn now to ground 2. Firstly, we asked the question, was a summary analysis appropriate? And we've identified in the Court of Appeal's judgment, which is the relevant passage is in the Appendix 1, MS 723.
Yes.
The pagination's right. It's in the core volume. The passages we ask the court to look at, in particular in this regard, are to be found between paragraphs 63 and 68, so MS 737 and following. And we say between 63 and 68, the court identified 2 steps. The first was whether or not the appellant was significantly prejudiced by the manner in which the trial judge moved to consider the exercise of the inherent jurisdiction. And secondly, whether the judge was in a position to make a sufficient welfare assessment. And then at 69 to 72, moves on to consider the judge's decision to make a summary return order and whether that was insufficiently reasoned or wrong. So we say between 68 and 69...
Now, what summary return order is he talking about there? The decision to make a summary return order was the Hague order. Is Lord Justice Moylan talking about the Hague order, or is he talking about a decision to make an order under the inherent jurisdiction, which, with respect to him, might not have been entirely accurate?
What we consider is they have relied on the Hague analysis and applied that to make their own decision under the inherent jurisdiction.
Well, there we are. We'll ask Mr. Setright about that. Yes?
And we say that there were two questions which should arise between question 2 and question 3, or between paragraph 68 and 69. The first would have been, is a summary evaluation of the forum type permitted at all, given the absence of any anterior wrongful act? And even if permitted, the second question, was a summary evaluation appropriate on the facts of this case? And in that regard, we have in mind the case of Rejay, and that is in tab 12 of the authorities. This was a case of wrongful retention, MS 280. So this is the child from the Saudi Arabian case, and one sees that G at the bottom of MS 280. Technically, had this been at H, had this been a Hague Convention case, this would probably have amounted to a wrongful retention of the child. And then, in relation to the exercise of the summary evaluation at 92C, internal page 92, MS 287, there's a passage headed, making the choice. In other words, even if one has the anterior wrongful act, even if it's the sort that might permit of a summary evaluation of the forum type, should it, in fact, on the facts of the case, lead to a summary evaluation? And at C, plainly there is always a choice to be made. We say that the Court of Appeal did not direct itself to whether this was a case where the choice should arise at all. We say it was not permitted. There was no wrongful anterior act, no wrongful retention or removal. And so a broader welfare inquiry should have been undertaken. And as to the choice, summary evaluation or welfare inquiry, the necessary consequence for summary evaluation is that it limits the questions on the agenda. To go back to section 1, it limits the question in issue. At no point did the Court of Appeal ask itself whether the issues that the appellant raised or might have raised should have been considered more fully in the best interests of the child. So we say summary evaluation was inappropriate, and in any event, we go on now to say that it was a flawed analysis. Firstly, it was flawed because, I've indicated, our primary point, it was the wrong evaluation. The analysis, it was the wrong question. The question should have been the broad question as to whether this child should live with the mother on her case, or go to Israel on the father's case, whatever in precise detail that case might be said to be, or indeed on cross-examination of him, turn out to be. I say that because in the first statement he gave undertakings not to remove the child, but the mother says that as part of her domestic abuse allegations that he made threats to remove the child had the child been returned to Israel. So that would be a matter for exploration at a welfare hearing. In any event, the Court of Appeal adopts the trial judge's inherent jurisdiction evaluation, and that falls short of providing any proper analysis, and that's not surprising because it was an adjunct. It wasn't the basis upon which the order was made. We say that in our case, we've set out the three evaluations that might be undertaken at the core bundle then, MS 704. Bottom of that page, paragraph 61, where we're looking at what we say is a flawed analysis, and then over the page, the three approaches, A, B, and C. So you've got the Hague Convention discretion, which is what the trial judge did. You've got the Re-J welfare approach, which the trial judge thought he could do. And once the Court of Appeal knocked out the wrongfulness, they thought they could do. But on the basis of the discretion exercise and the welfare that was in play in that exercise at A, we say the right approach was C. And I, of course, here, my Lord, in relation to the word relocation, perhaps I can simply say a wider welfare assessment.
Yes.
So we say it wasn't a wider canvas, but a completely different canvas. So in relation to the welfare aspect that is considered when looking at the exercise of discretion under Hague, perhaps one can start with the issue of habitual residence.
Can I just understand your point about wider canvas? I think I do, but I think we should focus on it, if you don't mind, Mr. Twomey. And I think that means going to the Court of Appeal judgment, paragraph 66, doesn't it? If you've got that to hand, it's 738.
Thank you.
Second line, I appreciate it could be argued the inherent jurisdiction has a wider canvas, based as it is on welfare being the court's paramount consideration. But when the court is deciding whether to exercise its discretion to make a return under the 1980 Convention, once a ground for opposing the return has been established, the court will consider the wider canvas. And so as I read it, Lord Justice Moylan is saying that the width of the canvas in a discretion inquiry is the same as the width of the canvas in a paramount welfare inquiry. And it is that, among other things, with which you take issue?
Lord, yes, for a number of reasons. Firstly, the wrong question is being asked. The question that's been asked in the Hague discretion is whether the welfare rises to meet and exceeds the policy of Hague, which otherwise would see the child return. That is a forum welfare inquiry, whereas the right question is the respective parties' cases on what should happen to this child. The second point is that welfare primarily arises out of the matters that gave the court the discretion in the first place, so that whatever it was that gave the court discretion will be the primary focus of the welfare inquiry. Thirdly, it's different. So I take two examples. Habitual residence. In a forum welfare analysis of this type, the simple fact of habitual residence is significant and points, as a matter of fact, therefore, to the forum being in the place of habitual residence. But in fact, in a broader welfare inquiry, it is those matters of fact that lead to the conclusion that there is habitual residence that are in play in the welfare inquiry. So it doesn't matter that you've got to establish habitual residence. What matters is how you have got there and any other facts that are relevant.
Well, thanks for helping us on that. And see, I speak entirely for myself here, but it seems to me that the welfare inquiry, where the paramountcy of the welfare of the child is a light that must shine on every aspect of the inquiry, is very different from the discretion inquiry. But if anybody can persuade me, and I'm certainly not speaking for my colleagues, if anybody can persuade me that that analysis is wrong, it would be Mr. Setright.
So maybe I was right to aim for an hour in reply, but I'm now restricted to my half an hour.
Well, you're eating into your hour, but an hour for reply is a long time. So bear that in mind, but proceed for the moment until you think you've completed your submissions.
It would be very helpful for me on the same point we've just been going on, to know at some point what your best formulation of the nature of the discretion in a Hague case is, from which paragraph of which case. I'm wondering whether it's M in 2007 at paragraph 43 and round about there.
Yes, it is. It's tab 15. I think it's 3, 4, 3. I think it's probably 343, paragraphs 43 and 44. Thank you.
Thank you.
And whilst I have, my lady and my lords, at that page, if I may, just to highlight, at H, thereafter, the weight to be given to convention considerations and to interests of the child will vary enormously. The extent to which it will be appropriate to investigate those welfare considerations will also vary. So even on a discretionary exercise, there is the capacity to go into more detail. It's also right that one of the conclusions of fellowship in this case was that it can be a consequence of the welfare, of the discretionary exercise, that a child is nonetheless returned, even where the child's welfare might indicate otherwise.
Because the interest in securing the object of the convention is so strong.
Yes.
Yeah.
Yes, where does she say that?
We'll find that, my lord.
Okay. Yes, that's it.
So the questions arising in this case, but not asked, were firstly, should I hear the merits of the competing cases? Who should have the care of the child and where? Rather than, should the child be summarily returned to the home country to determine issues? If not a welfare inquiry, and it's limited to the forum-style issues, should I deal with that in a summary form? Or, as Maris Hale said, should I inquire further into welfare? And so it means, Lord, I'm grateful, it's actually a different case.
Different case.
I'm sorry, it's Re J and it's paragraph 20.
Page?
MS 284.
Thank you.
But it means in this case that the welfare issue remained undefined. So that issue, that question under section 1, remained undefined.
I beg your pardon, which paragraph is it in on page 28?
Paragraph 20, at H, this necessarily meant.
Yes.
So how could the judge decide whether areas required further investigation when he did not know what the competing arguments or cases were? Was he looking at the mother's application that might have arisen under a child arrangements order, the father's application for one? Is he simply asking the forum question? We submit he was. In fact, it's our case that having determined the Hague proceedings, he was functus officio. He was there to determine those. Those proceedings ended. There was no other application. That was the end of the matter. But if he wanted to hold a full welfare inquiry, then it certainly required an application before him in family proceedings. We say that whether it be termed relocation or otherwise, the correct analysis is that set out in Re-F, to which I've already taken the court. Now, can I turn to the specifics of this analysis? Because the Court of Appeal upholds this analysis, and the relevant passage of the trial judge's analysis is to be found in at MS 768, the back of the very last page of the core bundle. And it's paragraph 73. As I've made clear, I'm satisfied that had I concluded that the child was habitually resident in this country, I would have reached the same decision under the inherent jurisdiction, pursuant to the principle set out in Rikiel, or sometimes referred to L, on the particular facts of this case. Now, when the judge determines habitual residence in this country, then, in my submission, he is effectively looking at what has been termed by the respondent as the technical defence to a convention case, so that there's been a wrongful act, but, for example, rights of custody have not been infringed because the absent father had none under his domestic law. Alternatively, there's been a wrongful act and the child has been so long in this country that habitual residence has shifted before the application for the return under Hague or the inherent jurisdiction arises. We say there is certainly, this is not a technicality, but that appears to be what the learned judge was doing. So it looks like he was determining, in his mind, had I decided that habitual residence as of the 10th of January, with the trigger date, the retention, the wrongful retention as he found it or thought it to be, then even if habitual residence had shifted by then I would have used the inherent jurisdiction.
But I suppose this is quite an important premise, perhaps, to his obiter dictum, had I concluded that the child was habitually resident in this country. If the child was habitually resident in England, that would betoken a degree of her integration in England, which would surely be relevant to the welfare inquiry.
Well, I agree, and indeed the judge said as much at the end of the paragraph at the top of the page. Paragraph 71 finishes with a phrase that reflects what my Lord just said. So at the time he was considering habitual residence in Israel, he spoke of the manifest benefit to the child.
Yes.
But what's he saying at 73? Is he saying, if I am wrong and it should have been categorised on these facts as habitual residence in this country, or let me postulate further settlement, which would lead to that finding?
I think what he's saying is if there was a technical defence, so Hague is issued, but the child's already habitually resident, then on inherent jurisdiction grounds, I order summary return anyway. Because it's an abduction, of course. In his mind, this is an abduction.
Yeah.
In his mind, the 10th of January is the trigger date. It's the important date. In fact, the important date for any exercise of discretion in any judgment is the date of judgment, or certainly the date at which the case concludes, and hopefully judgment soon follows. So we say it's significant when even looking at the internal analysis of the discretion, got two significant features. One, the wrong factual background as to wrongful retention. He was wrong about that. But secondly, it's not just that habitual residence is to be considered here rather than there. It means that in the balance, it comes out over here. So that one goes up, that's lighter, and it goes into this balance, and then it goes down on this side. So we say that internal, looking at if we were stuck with just looking at the exercise of his discretion, which would be usually a difficult task to challenge, we say, in this case, not so. In this case, for those reasons, it is a flawed analysis. And so in summary, we say that it should have been a side-by-side comparative analysis. There should have been an identification of what the true issues were, Hague having been swept away. Of course, much of this is not a fair criticism of the trial judge, because this is an adjunct, obiter, as my lord says. This was not the basis of his order. And then he should have been looking at what those welfare issues were. The shift in the habitual residence from one side to the other, the absence of the policy considerations under Hague. We say there was a limited acknowledgement of the effect on the mother, on the effect of the Article 8 rights of mother and child, and Article 8 interestingly refers not just to private life but home. Their home was now here. They had a lease for 12 months. And of course, we say necessarily, because it was a forum approach to welfare, he didn't approach the serious allegations of domestic abuse correctly.
Sorry, can I just go back before we lose it too far? They weren't living in that premises where the lease was taken, were they? Because there was an application to to remove the passport because they weren't any longer living there.
May I just check
Yes.
the answer to that?
It'll wait if you haven't.
No, the answer is that after the 10th of January, so when the parties separated, mother could no longer afford the rent on the lease, and so she moved.
Whilst I've stopped you and you were just about to deal with domestic violence allegations, was there any exploration of the effectiveness of undertakings that the father was offering in that respect in Israel?
No. So I think we need to be plain with the court that although Israel is not a Hague 1996 country, that issue was not brought to the court's attention at the trial. But
so was everybody to assume then that they were effective?
I think the Court of Appeal Authority, I think, is to the effect that it is for the court to satisfy itself that the protective measures will be effective, not that they are in some form illusory or paper thin, but they will have effect. And this is, I suppose, where one does possibly unfairly have to criticise the trial judge because it wasn't raised with him. But it is the court that has to hold that inquiry into whether the protective measures...
Mr. Kumi, I've been gone from the division for a long, long time now, but I seem to recall that in my day, before there was an order under the Hague Convention or otherwise for a child to be summarily returned to a foreign jurisdiction when undertakings were offered, the court had to be satisfied that those undertakings had been accepted by the foreign court, lodged with the foreign court, and accepted by the foreign court as binding. Is all that gone now?
Yes.
Why?
It's a very summary approach.
I see. Very well.
And also the 1996 convention covers quite a lot of the ground.
I suppose that is true, of course, yes. But where it does not, then... The way we put it in the Court of Appeal is in the appendix MS 921 to 922. Paragraph 31, judge did not consider whether the proposed protective measures would take effect in Israel, so provide any protection at all. There are undertakings proposed by the father, a letter from the Israeli ministry. That was a fairly general letter to the effect that they're a civilized country and have refugees and the like. It was argued that there was nothing to suggest the protective measures would have protected mother and child. But the concession had to be made, and the Court of Appeal's attention drawn to the fact that the point about the 1996 Hague Convention was not put to the judge by either party. And so he was not assisted, not least by on our part, in that regard. Thank you. And my lords, Lord, my lady, in those circumstances, we say that the Court of Appeal's decision was built on the weakest of foundations. It was to make a substantive order on the basis of an adjunct, which itself was based on a flawed analysis. And for that additional reason, we ask the Court to set aside the order that flows from it. Lord, ground 3, I hope I can take relatively briefly indeed, as I must. But I have already indicated to this Court that there were a number of questions, assuming for the moment that the judge was not functus officio, assuming for the moment that there was an implied inherent jurisdiction to which he was entitled to turn. Then we say he should have asked those questions. What is the jurisdiction now? If it's the inherent jurisdiction, should there be an application under the Children Act? What are the welfare issues arising? How do I deal with them fully or summarily? How do I deal with the question of Israel and protective measures? And in respect of none of those, was there a prior application, prior notice, written submissions, or oral submissions? And just to postulate for a moment, imagine if in the course of the applicant father's closing submissions, just before he sat down, as he would be the last to sit, it being his application, the last to speak, I should say, it being his application, just as a throwaway, he said, well, of course, we would ask you to exercise your lordship's jurisdiction under the inherent jurisdiction, notwithstanding the absence of an application. It is inconceivable that a judge in those circumstances would not, at the very least, turn to counsel for the respondent and say, well, what do you say about that? And that didn't happen. And so we say that the situation is worse. We say it's important for those who bring their cases to court to be able to rely on the proper functioning of the justice system, and that reliance is based, amongst other things, on the certainty that a party to the dispute will be heard in respect of all those items in the case. In other words, it's legitimate for the parties to a dispute to expect to be consulted as to whether a specific application or argument, as may be the case, calls for their comments. We say that the concept of a fair trial implies, in principle, the right for the parties to a trial to know the issues that the trial judge is considering and to comment on all the issues. And that is important, not least because it is the parties, specifically in the case, but more generally, confidence in the justice system to know that that is how their cases will be dealt with. So for that reason, we say that the authority, the bouche that we rely upon, if that's, I think, the last La Bruche, tab 14, which is judgment of Neuberger.
Yes.
My Lord and my Lady, please, if you want, to paragraph 24 at MS 320. This was a civil strikeout application. not the welfare of a child. What a judge cannot properly do, however, much he believes that he has fully read and fully understood all of the documents and arguments before coming into court, is to dismiss the application without giving the applicant a fair opportunity to make out his case orally. It's vital that justice is seen to be done. But that is by no means the only or even the main reason for this. It's also because it's vital that justice is done. Any experienced judge will have the experience of coming into court only to, with a view sometimes strongly held as to the likely outcome, only to find himself a very different view. That's a subsidiary point, perhaps. We rely particularly on the first. Lord, my ladies, those, I think, are, unless I can assist the court further, my submissions.
Did I understand that Mr. Horton is not appearing as part of your team now?
Lord, that's right. I should have made that clear at the start. He was very helpful in making his
Very well.
assistance.
So who is your principal junior now? Is it Mr. Lang or is it Dr. George?
It must be Mr. Lang whose case this is.
Very well.
But
Well, then it is to him that I ask this question. Mr. Lang, do you follow?
Thank you.
Right. There are 23 minutes knocked off your 60 for reply.
Much obliged.
Mr. Setright.
May it please my lords and my lady, can I first thank the court for the extension of time that we were given
Not a bit.
in our written case, and can I also apologise for its length. It's an ancient adage that if we'd had longer, it would have been shorter, and I'm deeply conscious of the fact that it is longer than we would have liked. So, my lady, if we were to look at the broad canvas of what's in issue, rather a lot is, but my learned friend presaged his case by saying that this is not, I might paraphrase, a mere technical case. And we say that ground one is not a mere technical case. It may have a considerable impact, notwithstanding the attempt by the appellant to bracket it as not affecting the use of the inherent jurisdiction in abduction cases, because, my lord, we asked the rhetorical question in the light of some of my learned friend's arguments about the availability of the inherent jurisdiction. Why not? Though some of his argument is it's inapposite, some of his argument is it's inaccessible. There seem to us, my lord and my lady, to be two principal thrusts of the appellant's case. One is that it was an inaccessible jurisdiction, and the other is that it was an inappropriate use of a summary jurisdiction, and we will need to address those separately. Then there are what are potentially technical grounds, at least in part, which relate in some regards to what is said under grounds 2 and 3. Inevitably, I'm going to spend less time on grounds 2 and 3, but I recognise that they are important, particularly perhaps ground 2.
You're right to recognise that. So please don't do other than put forward your best foot on ground 2, Mr. Setright.
My lord, the approach that we have, and it's right that I should indicate that as well, is this, that there are some areas where, in a technical sense, it may be said with some force that things didn't happen. For example, there was not parce the heading to the application and the other matters that have been mentioned. There was not express mention of an inherent jurisdiction application. That is a matter which was not addressed in counsel submissions on either side, as I understand it, in the case that was heard by Mr. Justice MacDonald, and the obiter pronouncement came at the end. and when looking at the foundation for some of the points made by my learned friends, they have, with great respect, some good points that they can make. Where we address those is to say, on the one hand, asking carefully but rhetorically, did it actually make a discernible, definable difference? And there, my lords and my lady, the way the case was run in the Court of Appeal involved some concessions made by my learned friends, concessions which, as the written case makes clear on reflection, they don't seek to maintain. But we say that it's not apparent from the material before the court that such divergences from what might be called good practice, if I'm putting my case cautiously, we would say these did not demonstrably have an impact. If they had had an impact, the case would have been run below in a different manner. But we say that if the court finds favour with the appeal under under grounds 2 and or 3, we would seek to persuade my lord and my lady to remit for further consideration on a correct basis, that is to say, embracing a consideration if the Court of Appeal fell into error, or if by proxy Mr. Justice MacDonald fell into error, of a correct approach to the inherent jurisdiction, or alternatively to look afresh at the evidence. So in summary, our approach to those grounds is to say they are not the root and branch broad canvas ground that one represents, and therefore, regrettably, we would say the court ought to remit so that there be a fair and just hearing. So that's by way of preliminary, and now I must, I think, launch into our approach to the broad case under ground 1. And plainly what I mustn't do is to plod through our written case, because even the generous 2 hours which we've allocated to ourselves would be inadequate for that purpose. So I'm going to take it that my lords and my lady are familiar with it, and that we hold to it. So highlighting just some points, that the first is one which arose in an observation by my Lord Wilson. The case is bracketed as a relocation case by my learned friends. We say that that is simply, first, not right, and second, not helpful, with great respect to them. One of the difficulties inherent in the appellant's argument is that they seek to choose in a restrictive way those areas in which it is permissible, subject to accessibility under the Family Law Act and other provisions, for trial judges to make orders under the inherent jurisdiction for the return, perhaps those words should appear in inverted commas and not as a state of art, of children, and those where they should not. We very much prefer, and invite the court to prefer, the approach set out by Lady Hale in Reed J, taken in isolation, always a dangerous thing for anyone to do, where she observed, and my lords and my lady, that is at MS 287 in the speech, for so it then was, of Lady Hale 12 years ago, paragraph 28, it is plain, therefore, that there is always a choice to be made. Now, what we know is that Lady Hale in J was not dealing, as it happened, with an inherent jurisdiction case. Very unusually, because in my experience of what that is worth, and it may be in the experience of some members of this court, the inherent jurisdiction is a frequent recourse as a backup to the Hague Convention, albeit sometimes pleaded and sometimes referred to in a way that it was not in this case. But here Lady Hale was talking, unquestionably, we say, about a summary return under the Children Act. And when she says there is always a choice to be made, that is a choice on a case-by-case basis between making a summary return or not making a summary return, and the way the court addresses the problem before it. It was, we say, an approach which the Supreme Court, also with Lady Hale as part of the panel, adopted in Re L 8 years later. There isn't a compulsion to consider a summary return or not to consider a summary return in each individual case, but on the facts, as they appear to a judge may think, well, yes, I think, having reached a determination, as the Supreme Court did in the Texas case, having reached a determination that this was not a Hague Convention abduction. And I remind the court, probably needs no reminding at all, that this was a case in which, by reason of a determination made by an American judge, a determination which was later held by the American appellate courts to be wrong, the mother perfectly lawfully removed to this country. It wasn't a Hague abduction. Indeed, it was, on the mother's case, a Hague return, which brought her offspring to this country. Habitual residence had plainly moved. The children had been here for about 2.5 years. They had acquired at least one half-sibling. There was a new adult relationship. There was an entrenchment in this jurisdiction.
Mr. Setright, you won't forget paragraph 37 of Lady Hale's judgment, the final sentence. It's on 313. Had it not been for our decision on habitual residence, it would have been our duty to return Kay to Texas.
Yes.
Under the convention.
Yes.
So are we not, when we look at Re-L, are we not looking at, broadly speaking, a wrongful retention? Doesn't come into Hague only because of the habitual residence point.
It's not an Hague case. Yet my lord is right, with great respect, to look at that. But the absence of habitual residence on the facts of this case meant there could not be a wrongful retention.
Which case? Re-L or
of Re-L.
The present case?
Of Re-L. So
yes, quite.
The absence of habitual residence had an impact on Article 3.
You see, I'm searching for examples of summary return under the inherent jurisdiction where the child's presence in this country is not, for one reason or another, wrongful.
Lord, as it happens, and I've alerted my learned friends to this, there was a determination made on Monday of this week. We're not in a position to put the judgment before your lordships today, but only because it's not yet been anonymised. It was a decision of the family division. It doesn't actually take anyone by surprise, because paradoxically, my learned friend Mr. Gratian and I were for one side, and those instructing my learned friends were also instructing us. And that was a case which, subject to my lords and my ladies' view, we can place before the court, once anonymised, the All England reports expressed an interest in it before the judgment was handed down, which is unusual, and we've been asked to anonymise it. But without going into the facts in any particular detail, that was a case, it's a Russian case, in which the judge held that there was not, emphatically, an Article 3 wrongful retention, that it was not a case to be decided by way of Article 13A, that this had been an agreement then breached. He was finding simply that there was no wrongful retention. On the contrary, there had been an agreement that for a lengthy period the child should remain in this country, and that therefore there was no unlawfulness about it. And he emphasised in his judgment that this was not therefore an abduction situation. There were, however, in the other country, pre-existing proceedings which were first in time, although the quote removing unquote parent had also started proceedings in this country. And the judge, on the primary basis that this was to appropriate in the context of those other welfare proceedings in the other jurisdiction, made a summary return. Now, the judge in that case had been alerted by us both to this appeal, for which leave had just been given. As we started the case on the first day, we obtained the written case of the appellants, and we also plainly alerted the judge to the judgment of Lord Justice Moylan in the Court of Appeal in the current case, and I summarised to the judge and to my opponent what the issues were. So that is
steered clear of Lord Justice Moylan's judgment, knowing that it was to be examined by us. Is that right?
I provided the highlights. Oh, yes, my lords and my lady. We provided the highlights of the way of the challenge.
Well, if that could be, when it's in a proper form, sent to us, and the appellant will have the opportunity to comment on it, that would be helpful. But then can I narrow my inquiry? Where is the reported case where a summary return has been ordered under the inherent jurisdiction in a case where the child's presence in this country was lawful?
May I have a moment, my lord?
Certainly.
Mr. Gratian wishes to say something to me. This real. Yes. Well, my lord, it may be slightly circular, but we say that that case, or an example of that case, is the Texas case, because the result of the finding on habitual residence is that there was not a wrongful removal, and the presence in this country was a lawful presence.
Well, we'll have to reread that, but that proposition might be controversial, Mr. Setright.
properly warned, I will look at that over the short adjournment.
Very well.
Mr. Sedgwick, can I add to your list a
Yes.
case with which you're all familiar, the Moroccan J case, which I think was an inherent jurisdiction case, which came up here and went back to the judge to consider under the inherent jurisdiction.
Yes. Yes.
I don't remember the circumstances of it apart from that, so perhaps you can help on that.
That also engaged the 1996,
Yes, it did.
which this case can't.
But that doesn't matter to the domestic format of the
doesn't.
proceedings.
My lady is quite right with respect. So may I add that to my list and come back to it along with much else at
So
your
25th, no, I can see puzzled looks, and so just so that everybody knows, it's 2015 3 weekly law reports 1827.
Yes, thank you.
And so, we say that the court, there isn't a need for the court to place categorical restrictions, that is, restrictions by category of case, on the access by judges. And incidentally, if this flows from Hague Convention cases, they will always be High Court judges or Deputy High Court judges, to limit the categorization of case, which may result in a recourse to the inherent jurisdiction. That's simply not necessary, there's no call for it, and if one goes back to the observations of Lady Hale, that there's always a choice to be made, the judges can be trusted in individual cases to apply the right welfare test and conclude, if they're invited to consider, or of their own motion feel that they ought to consider a summary return, the appropriate paramountcy of welfare and the appropriate course that the proceedings take, which may be a summary resolution, or may be a full welfare inquiry, or may be conceivably something in between, because there must be a flexibility. A judge with a case of that kind may say, well, there is X and Y that I feel should be thoroughly investigated, but there is A and B, which, were there a full welfare inquiry, might be traversed, which I find no need to go to at all. We don't suggest that there is a huge number of cases which are other than quote abduction, unquote cases, which will result in consideration of summary inherent jurisdiction returns. But if there are some, then it is appropriate that the recourse remains. The other question, which is one of strict jurisdiction, well, we will turn to address appropriately in detail by reference principally to the Family Law Act. And there our case is that the Family Law Act is quite careful, I take away the quite, that's sloppy, the Family Law Act is careful to maintain both recourses. And in as far as the practice direction, to which my learned friends have taken the court, appears to suggest otherwise, then we say that the practice direction goes too far and is not right. But let me turn then to some detail. And we say that we respectfully agree and adopt that which appears at MS 1272, paragraph 9, of Reunite's intervention, that if ground one, and this reflects part of our
Which
written
paragraph
case.
is that?
I'm so sorry, Maud. Paragraph 9,
9.
1272, I hope. where effectively if ground one succeeds, it runs the risk of effectively rendering redundant the entire inherent jurisdiction in relation to the international movement of children in child abduction cases by mandating a substantive Section 8 Children Act application instead. Well, some of my learned friend's submissions seem to suggest that in order to deal with a case under the Children Act, quite a lot of things would have to be done. He's not strong on this, I mean, he doesn't press it, but arguably there'd have to be safeguarding. Safeguarding being, for those who've not encountered it, a paper exercise in which certain inquiries are made into the parents, involving an examination of public records. The difficulties in engaging in a safeguarding exercise where one of the parents is not in the jurisdiction make that a different sort of task from that which is entailed in an inquiry where both parents are in this jurisdiction. It would entail various procedural steps which now exist in the way that we deal with our private family law cases in this country. An attempt to encourage mediation, a pre-hearing at which issues and attempted reconciliation of those issues takes place. It would entail, as my learned friend cites it, a consideration of, for example, Practice Direction 12J in cases where matters of domestic abuse are raised. It would entail, he says, a consideration of the checklist at Section 1.3 of the Children Act. It would entail a great number of things. We would say two things, my lord, and my lords and my lady. First, that the use of the inherent jurisdiction, not specifically designed to avoid these things, but to embrace a general and overarching approach to welfare, does not actually present any disadvantage to children, but presents an advantage of speed and efficiency over such an approach, which is proportionate to a case in which a judge envisages that there's a need in the child's interest for a summary return. No other basis for a summary return under the inherent jurisdiction would be admissible. And I'm going to come to my Lord's question about the distinction between welfare as seen, this is not quite the way my Lord packaged it, welfare as seen in the way the discretion is addressed, following a finding that one of the so-called defences under the 1980 Convention is made out, and welfare as seen in the application of the inherent jurisdiction to a summary return case. And that's, I'll certainly come to that. But, my Lord, we say it's untrammelled welfare. But second, that my learned friends may understate the ability to have a summary hearing under the Children Act. Because, again, reverting to Lady Hale and the prototypical J, there's always a choice to be made. Lady Hale, we say, was plainly contemplating a summary hearing. Just as just as the Supreme Court in the Texas case plainly contemplated and in fact held a summary hearing. I put it in that way because this court, there I go again, the Supreme Court was in effect, we say, substituting its decision for the decisions of Mr. Justice Singer and the Court of Appeal, which was not to go down the inherent jurisdiction road. this was an example of a true summary return on a careful but nonetheless limited balancing of the available welfare evidence. So, as my Lord may remember, unfortunately I was on the losing end of that one, and of course tried to persuade the court that it shouldn't do it. And the court declined to engage in to remit for a further welfare inquiry. There was quite enough material to do it.
Well, my Lord Hodge was in the case as well as
yes. But of course it doesn't remotely fall to me to speculate as to the reasoning process which the court had beyond what is spelt out in the judgment, but it must have been apparent to the members of the court that it was right and just in all the circumstances and consistent with welfare that that child be returned after 2.5 years in this country on a summary basis. And we say that that is an excellent and perhaps on the authorities an extreme example of how the power can be used, and used as arguably it was in the present case, and here I come to another of my Lord's questions, by an appellate court. Because my Lord Wilson said I would in due course have to address this question, which was in effect, who made the inherent jurisdiction return order? Can one salami slice Mr. Justice MacDonald's decision and say, well, if the determination under the Hague is removed, what one is left with is a determination to return? Well, I'd have to, I think, accept that that wasn't necessarily the construction. It was an if I am wrong. It's arguable both ways, but it may be, and this is a partial concession against myself on timing, it may very well be that there's a fairly strong argument that it was the Court of Appeal that made the return order, having dismissed the determination under the Hague. But, my Lords, I'm not willing to make an unequivocal concession of that. All one can do is to look at what Lord Justice Moylan said, and it is a complicated process, because undoubtedly his starting point was what Mr. Justice MacDonald had said. There are all sorts of arguments about it.
On the date point, ought we to look at paragraph 71 of Lord Justice Moylan's judgment,
Yes.
which we've got at 739, Mr. Setright, and 5 lines down, you will remember the sentence. Further, the judge's determination as to the exercise of his discretion was inevitably made at the date of the hearing and order.
Yes.
Now, that's talking about discretion under the Hague Convention, because that was the order he made. But the logic of that sentence, which I'm sure is correct, is that when the Court of Appeal makes an order under the inherent jurisdiction, the relevant date for assessment of the circumstances would be the date of its order in June, and were that right, you would need to tell us what the evidence was in relation to June.
Taking it stage by stage, first of all, Mr. Justice MacDonald, because this was in the nature of the case that was being run by the mother, had a very great deal of welfare evidence, and that welfare evidence dealt with the period up to the hearing, or rather, of course, up to the date of the completion of the mother's written evidence, which was a very short time before that hearing. So that took one to April, and in April, therefore, Mr. Justice MacDonald had up-to-date and fairly full welfare evidence. The question was, a question was, my lords and my lady, what did Lord Justice Moylan and the Court of Appeal have? Well, they, I'm not being facetious, they had what they were given. And what they were given in this regard was fundamentally the material that was before the judge at trial. Now, I don't wish to be critical, and no one operates entirely immaculately when one applies the dubious benefit of hindsight. But we all know that a children's case allows a departure from the strict terms of the rule in Ladd and Marshall, and that updating evidence can be produced before the Court of Appeal. More than that, if it is said that a decision is wrong, and if it is said that supervening events or material can be produced which would not have been available at the time of the hearing before the trial judge, which can demonstrate that it was wrong, then the admission of that material would be in accordance with the rigours of the rule.
But the appeal was against the Hague Convention order. That was the parameter of which the appellant was aware.
But nevertheless, in the appeal, and I wasn't there as my lord and my lords and my lady will know, although to put it in context, Mr. Jarman was actually at the hearing before Mr. Justice MacDonald, and there will be, with my lord's and my lady's leave, a follow-on from him dealing with at least some of the arguments.
But before we finish this,
yes,
your side would have agreed to the adduction before the Court of Appeal of fresh evidence relating to welfare?
Weren't asked. None was suggested. If there had been an application, first if it had been said that there was fresh evidence of materiality, then arguably the Court of Appeal would have found it very hard to refuse an application for that evidence to be admitted for evaluation. But there wasn't a request for further evidence to be introduced, as I understand it. My lords and my lady, I've reached 1 o'clock, sort of mid-point, but I'm happy to break there.
Well, if you're
that's
happy
convenient.
to break there, so are we. And we look forward to hearing from you further at 2 o'clock.
And I'm checking my time.
You started
got an hour and
at
23 minutes.
You started at 12:23, and you've got 2 hours.
So
We can work it out.
An hour and 23 minutes, although I'm not a financial practitioner.
Thank you.